Good day, everyone. My name is Scott Reich, and this is Crime Talk. Yes, we have all of the top stories throughout the week located in one convenient location right here for your enjoyment. I hope you enjoy it, and you don't need to leave me a message stating that, hey, I've seen this before. It's a recap, hence the term recap. Thanks for watching. We'll see you next time. Is Lori Vallow. Her sentencing is coming up on murder charges and all remaining charges in which she was convicted, and she will be sentenced by Judge Boyce in Fremont County at 9 a.m. on July 31st. So that is next Monday. Well, what can we expect to see? Could she get life? Yes. Will she probably get life? Absolutely. Does she deserve it? Absolutely. Will the judge do something radical? No. Judge Boyce's bold move was to dismiss the death penalty because the discovery delays regarding the production of documents by the prosecution. And frankly, that's just a nice way of saying that the prosecution couldn't get their act together. And let's be clear, I'm not saying Lori Vallow is innocent, but it's troubling that the prosecution had 3 years to dot their I's and cross all their T's, but couldn't get it done. Vallow will have more appellate issues because the defense in this case was so weak. Now, usually what you expect to happen is going to happen in court. But I give you a little bit different perspective than most people are talking about. Well, why? Because, well, I've actually read all the motions in this particular case. Now, let's go back to early January of this year. Do you remember the notice of intent to raise the mental health defense? Yes. Now, remember, the state of Idaho does not have a not guilty by reason of insanity. And the defense filed a motion, and they cited to Idaho Code Section 18-207. And they say they give their notice of intent to raise a mental health defense at the guilt phase portion of the trial, right? You can't do it during the trial itself because that's prohibited by law, but you can bring it up, and they gave their notice of endorsement. So they said they will provide a list of expert witnesses to be disclosed 90 days prior to trial, and they expect to call those to negate elements of a crime. This advanced disclosure is required for the guilt phase portion of the trial, and they filed this back on January 3rd. And the defendant's mental health has been evaluated and litigated since the first filing in this case. Mr. Archibald let the prosecution and court know, and he let them know and reminded them that she had spent 10 months at a mental health facility in Idaho and received mental health care from the experts employed by the state of Idaho. The defense has hired 3 independent mental health experts to review and evaluate Lori Vallow's mental health. And due to the ongoing mental health concerns while this case has been ongoing, the court conducted an evidentiary hearing back in November 10th of 2022 to determine if she was even competent to proceed to trial. And then on November 15th of 2022, the court ruled that she was in fact competent to stand trial. And although still suffering from a mental illness, her defense attorneys noted that she is taking an active role in her defense, and she's previously reviewed all of the discovery provided to her by the state and her attorneys. And she's consulted with the 3 mental health experts, and she doesn't want to proceed on a mental health defense to negate the elements of a crime in this case. She has not authorized her attorneys to proceed with a mental health defense in the guilt phase portion of the trial. Her attorneys are respecting her autonomy and her rights granted to her by the Constitution of the United States. If she's found innocent of the charges, which obviously didn't happen, then no disclosure would be necessary. But if she's convicted, then the defense is going to call witnesses, including experts, in support of mitigation during the sentencing hearing. Yes. Do you remember all that? I haven't seen anybody talk about it. So now comes all the mental health stuff. And 18207 of the Idaho Code, it says the mental condition shall not be a defense to any charge of criminal conduct. But then in the next paragraph it says, if by the provisions of this section, 19-2523 Idaho Code, the court finds that one convicted of crime suffers from any mental condition requiring treatment, such person shall, which is mandatory in the law, shall be committed to the Board of Corrections or such city and county official as provided by law for placement in an appropriate facility for treatment, having regard for such conditions of the security as the case may require. In the event of a sentence of incarceration has been imposed, the defendant shall receive treatment in a facility which provides for incarceration or less restrictive confinement. In the event that that course of treatment thus commenced shall be concluded prior to the expiration of the sentence imposed, the offender shall remain liable for the remainder of such sentence, but shall have credit for the time incarcerated for treatment. So what does that mean? Yes, Lori Vallow, if they present evidence, which their attorneys say that she will, I'd be surprised if they did not, is found to suffer from a mental disease, guess what? She's going to go to a mental hospital. Now, it doesn't mean, according to the statute, that she is going to somehow get it easy and get out early. It just means you're going to get credit towards that ultimate sentence. But the court will probably consider if she does suffer from some sort of mental disease or defect, well, he may not impose the maximum sentence. I think the mitigation has already taken place, basically in chambers, since most everything for the Lori Vallow case was done in chambers, and we weren't entitled to see or hear that. But like I said, the bold move, and the biggest move that the defense can ultimately receive was the dismissal of the death penalty. That was a win in the eyes of her attorneys. Now, regardless of what happens next Monday, there's going to be an appeal. That'll probably take 3 to 5 years. Then the post-conviction work will begin. And that is basically where they allege that her attorneys were completely ineffective and it resulted in an unfair trial. Join us on Monday at 9:30 and we will all find out together what's going to happen. Carlee Russell, liar, liar, pants on fire. Carlee Russell has revealed that she made up seeing a toddler on the side of an Alabama interstate and then made up being kidnapped as the police and the district attorney consider filing charges against her. Now, the 26-year-old nursing student sent a statement to police admitting she had been in the area of Hoover as hundreds of people desperately searched for her for 49 hours. Now, Russell had claimed that she was kidnapped on July 13th after she stopped to check on a toddler about 9:30 p.m. She turned up at her parents' house and told police that she had been abducted, spinning a somewhat elaborate story of fighting to get away for her freedom. Well, on Monday, Hoover Police Chief Nick Derez read a statement from Russell's lawyer in which she admitted she had invented the entire story and said that it was a hoax and it was a big mistake. No, a mistake is when you turn on the wrong street. This was a thought-out, elaborate plan for who knows what reason, attention, whatever. It doesn't matter. She lied. She should be prosecuted. Like I said, the prosecutors are still trying to decide if criminal charges should be filed. Seems like a no-brainer to me. And there's been no indication of any motive for the staged disappearance. And no explanation as to where she was for the 49 hours while she was gone. Now, Miss Russell stopped cooperating with police after returning home, but initially told police that a white man took her and that this white man had orange hair who appeared from the trees on the side of I-49 after she saw a baby boy walking around in a diaper along the side of the road. Well, last week, the police chief said that they had been unable to confirm Russell's story and wanted to speak to her to clarify these details. She refused to speak for the second interview, and police said they were scheduled to meet with Miss Russell on Monday, but her lawyer provided a statement and read it to the public. Her boyfriend, Thomas Simmons, had initially been among those frantically searching for her and expressed his relief when she turned up safe. But after Wednesday's press conference, he has erased all trace of her on social media. Russell's family are not believed to have been involved in this little elaborate scheme that she went through. And then on July 17th, the day after she returned to her parents' house, they recalled how they found Russell in a bad state. She fought for her life. Her father, Carlos, a vice president of underwriting at BBVA Bank. Russell left work at Woodhouse Spa in Birmingham, Alabama around 8:20 p.m. on July 13th after stealing a bathrobe and toilet paper. She then stopped to pick up food for her and her mother. Russell traveled towards Hoover and called 911 about 9:30 to report the missing child wandering on the side of Interstate 459. After calling 911, Russell reportedly called her sister-in-law to tell her she was going to check up on the child. The family member lost contact with her about 9:36 p.m., and the line remained open. Now, responding officers located Russell's abandoned car along with her cell phone, her purse, wig, and Apple Watch in the nearby area, but no sign of her or the alleged child. And the Hoover police said they've never received any other calls of someone else reporting that there was a missing child. 2 days later, Russell returned to her family's home alone. Now, the police said on Monday it seemed there was a significant degree of planning in this whole thing. You think? Like, who picked her up? Where'd she go? Well, the police are unable to say how much of the 49-hour search operation cost as of yet, but basically they're trying to decide whether Carlee should have to pay for it. The police noted that large numbers of volunteers, uniformed officers, and canines searched for Ms. Russell for days with helicopter support. And let's face it, helicopter jet fuel, it's expensive. The police said they don't have a dollar figure yet, but they're certainly working on getting one, and not only ours, but the other agencies that gave us a lot of support, the police have stated. Oh, and by the way, on top of losing her career as a nursing student, her boyfriend's dumped her. She's forever shamed as being a liar. She also got fired, probably for stealing that robe and the toilet paper. Anyway, let me know. I think she needs to be charged. Restitution should be big, and at minimum, charge her with stealing the bathrobe and the toilet paper from her employer, just so something sticks on her record. Please go to crimetalksearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. Anyway, next on the docket, Bryan Kohberger. Alibi? No alibi. Well, this broke last night. We talked about it on our live program last night. And Bryan Kohberger has claimed that he is not the person that was at the house that where four college students were murdered, and he was going to submit to the court a notice of alibi, and the deadline was in fact on Monday. Instead, in the pleadings filed by the defense, they filed what presents something that they are going to prove later during cross-examination through witnesses called by the prosecution, that Bryan Kohberger was not there. Now, the state has claimed that Kohberger's DNA was recovered from a knife sheath left behind at the murder scene, and that a white Hyundai owned by Bryan Kohberger was seen nearby at around the same time. In a notice filed on Monday evening, Kohberger's attorneys wrote that their client would be invoking his constitutional right to silence and would not be submitting an alibi defense. Mr. Kohberger's defense team continued investigating and preparing his case, they wrote in their pleadings, and evidence corroborating Mr. Kohberger being at a location other than the King Road address will be disclosed pursuant to discovery and evidentiary rules, as well as statutory requirements, basically suggesting that the evidence will come out through expert testimony as well as witnesses called by the prosecution. There was also another motion that was filed by the defense, basically suggesting that the DNA linking Bryan Kohberger to the knife sheath must have in fact been planted. They argue that the state's argument asked that this court and Mr. Kohberger to assume that the DNA on the sheath was placed by Mr. Kohberger and not someone else during an investigation that spans of hundreds of members of law enforcement and apparently at least one lab that the state refuses to name in their motion. The defense also wanted more information on how the FBI used the DNA to create the family trees that led them to Kohberger to begin with. The prosecution says, we're not going to use that since we had probable cause to arrest him. We got a 41-1 order where we got his saliva swab. We sampled that, created the DNA profile and compared that to the DNA profile. So everything that the FBI did is completely irrelevant and you are not entitled to it. But one more thing, as it relates to the alibi, let me tell you, ladies and gentlemen, I have never had an alibi work at trial. They don't work. Because if you had a rock solid alibi to say that it wasn't you, you would disclose that immediately and present that to the district attorney to say, look, I wasn't here. And the reason why I say I've never had an alibi work at trial is that I've had them work pre-trial, where you say, look, my guy wasn't here. Here's the proof. They check it out. Oh, sorry, wrong guy. Case dismissed. Now, if I was Brian Kohberger's attorney and I had a rock-solid alibi, I'd probably want to get this case wrapped up as quickly as possible and get an innocent man released from custody. Now, of course, if they don't have that alibi, then you got to say, well, here's my alibi, not alibi. Just something to think about, ladies and gentlemen. That's right. Miss Schabusiness found guilty. Can you believe it? Oh, my goodness. Yes, the Wisconsin woman was found guilty of killing and dismembering an ex-boyfriend and scattering his body parts, and then was seen laughing in court as jurors were shown new videos where she revealed how she played with various body parts in very graphic detail. Taylor Schabusiness gave a disturbing detail to the police during an interrogation video about choking her ex-boyfriend, Shad Theron, to death, and, well, frankly, how much she liked it. She also revealed that her lover's head was allegedly the first item removed. There were other things that she was cutting and sucking simultaneously, but, well, last time we talked about that, we got demonetized, so you get the picture. Anyway, Miss Schabusiness said in the video, I liked it. I didn't know what to do. Well, anyway, the Brown County jury deliberated less than an hour before convicting Schabusiness of homicide, third-degree sexual abuse, and mutilating a corpse, going back to the February 22 killing of Mr. Theron. Now, guess what? The trial moves into a second phase to determine whether Miss Schabusiness suffers from a mental disease or defect, and whether she should be sent to a mental institution or go spend the rest of her life in prison. Now, authorities allege that Ms. Schabusiness strangled Theron at his Green Bay home he shared with his mother, sexually abused him, and dismembered his body, leaving parts of it throughout the house and in a vehicle. His mother found various severed parts in a bucket in the basement of the home, whereupon she promptly called the police. The Green Bay Police Department Detective Graff testified that Schabusiness had allegedly confessed to cuddling with her former boyfriend's headless corpse after the killing. She went into great detail how she had sexual contact with the body as well after her boyfriend was no longer with us. She described that she had various toys that she placed into his mouth as well, and that she cuddled his body. You can't make this stuff up, ladies and gentlemen. It was interesting. The prosecutor said in their closing, you just can't make this stuff up, really. I mean, it's just so weird. And the defense's argument was, hey, was this an accident? You know, I get it. It was an accident, and therefore we chopped everybody up. Yeah, not so much an accident. At least that's not what the jury believes. Anyway, we'll let you know where she's going to go spend the rest of her days. One could say she's got to be crazy to do what she did, or she's just a sick, demented person. Let me know in the comments what you think. Sick or demented? So Carlee Russell, take a look at her new mugshot. She's smiling, keeping her chin up. That's right. She's the Alabama woman who told police she was kidnapped after she went missing for 2 days. Well, she was arrested this morning and charged with 2 misdemeanors for making false statements to police. Now, the police chief expressed great frustration that Russell was only charged with a misdemeanor and said that he is calling on state legislators to add an enhancement to the statute that when somebody falsely reports kidnapping or another violent crime, that it be punished more severely. Existing law only allows the charge to be filed as a misdemeanor, the chief said. And since Ms. Russell was charged with 1 count of false reporting to law enforcement authorities and 1 count of falsely reporting the incident, he added that the charge, they only carry a $1,000 bond, and it's only punishable by up to 1 year in jail and a $6,000 fine. Now, here's my thinking. My guess is in that room was probably a federal agent. And we know, based upon the last story about the property manager in the Trump indictment, if there was a federal agent in the room and she lied, charge it as a federal crime, lying to a federal police officer. They could charge it under the Assimilation Act since there probably wasn't interstate commerce involved. Hey, you got to get creative on these type of things. Misdemeanor for the time that she wasted, the fear, the panic she put everybody into. Certainly there must be some sort of attempting to influence a public official that's a felony down there.